In essence, the state of Alabama has told the United States of America they are not about to abide by the law of the land. When it comes to gay marriage, they are refusing in some part to follow the Supreme Court's call and will make it on their own. It has torn the state in half between those who are listening to their state's legal opinion and those who decide the United States makes the overall call. So now let's turn to the legal side of this issue and welcome to MidPoint, professor of law at New York Law School, editor of Lesbian and Gay Law Notes, a chronicle of legal aspects with regard to the LGBT community. Arthur Leonard joins us today. Mr. Leonard, thank you so much for being here.
You're most welcome.
Is it not fair to say that when we look at the law of the land, the Supreme Court has absolute right in this case, and going against them as Alabama does is simply not something that a constitutional law scholar would say that is proper or smart?
Well, I certainly would say it isn't smart. The situation that we have is that a federal district judge has declared the state's ban on same-sex marriage, both in its constitution and in its statutes, to be unconstitutional. Now, technically, the order that she issued only runs against the Attorney General of the state, and the Attorney General doesn't run the marriage license business in that state. It's run by the probate court judges. So now it's up to those judges to decide whether they will comply with the federal district court's decision when the Supreme Court refused to stay it. That is, the state obviously can appeal that decision to the 11th Circuit and ultimately to the Supreme Court, although given the pace at which appellate procedures go in the federal system, they probably wouldn't get there and actually have a ruling before the Supreme Court decides this question in other pending cases.
Does this not then go back to what former Arkansas Governor Mike Huckabee said recently when he said that the governors and the state legislatures must consider ways to resist Supreme Court decisions that recognize same-sex marriage as a constitutional right? When he talks about resist, there really is no legal way to resist on an automatic "we won't do it." Is that correct?
That is correct. The federal courts are the arbiters of the meaning of the Constitution, and ultimately the Supreme Court is the arbiter. Now, we're in a very unusual situation here, and that is that the Supreme Court in October refused to review decisions by 3 federal circuit courts of appeals in favor of marriage equality. That is, holding that the Constitution requires the states to allow same-sex couples to marry. So that decision in October not to review those cases allowed same-sex marriage to go into effect ultimately in several dozen states around the country since then. And the Supreme Court has been asked numerous times since October 6th to put on hold federal district court decisions ordering same-sex marriage, and they've refused to do so every time. Most significantly, they refused to do so in Florida, where the Court of Appeals, to which Florida would be appealing that ruling, had not yet ruled on the ultimate question. And this week, they refused to do that in Alabama. And so that sends a pretty clear message to people. In fact, in his dissent yesterday from the Supreme Court's refusal to stay the Alabama decision, Justice Thomas said, well, the Supreme Court is sending a message out there about how they're going to finally decide this issue, which isn't appropriate to do until after they've heard arguments and received briefs.
Well, let me look at it from this way.
They seem to be sending a pretty clear message out there.
Let me look at it from this way, if I can. Alabama and Chief Justice Moore says, absolutely not, we won't do it. We have some counties that are going along with him. Some basically are following the lead of the Supreme Court at this point. Does the Supreme Court / the U.S. government have any recourse whatsoever in order to go into Alabama and force them to abide by the Supreme Court decision at this time?
Well, you see, the Supreme Court hasn't made a ruling on the merits yet.
Correct. That's the point of it.
There is no Supreme Court decision to enforce. All they did was turn down the state's request to stay the district court's decision. Now, that leaves it to the people in Alabama to initiate the necessary actions. And 2 lawsuits were filed yesterday in Alabama, in the U.S. District Court in the Southern District, the same court that decided the marriage case a few weeks ago. One of them is once again against the Attorney General, but adds a request for a much broader injunction that would demand that state officials comply. And the other one is a new lawsuit which files it names as defendants just about any state official that you could hope would be involved with this. It names a probate judge, it names Chief Justice Moore, it names the governor, it names the Attorney General, it names the court clerks, and it says, please give us relief. And these were both filed yesterday in the federal district court, and if the judge issues an injunction running against these officials, then that could be enforceable by U.S. Marshals.
I've only got about 10 seconds left here. Do you think that Justice Clarence Thomas sort of tipped the hand on Monday when he basically said that the majority of the justices may have already made up their minds on what their decision will be in April?
I think he was saying out loud what everyone has been concluding already.
Would you think then at this point that what the gentleman is doing in Alabama is nothing more than grandstanding and futile?
Well, he's got a political base. He's an elected Chief Justice, and he's playing to his base.
There you go.
And I think he probably sincerely believes in what he's saying.
I have no doubt that he believes in what he is saying. Mr. Leonard, thank you so much for joining us. I look forward to the next time we speak.
Thanks.
Coming up next, the Motor City Madman. Ted Nugent joins MidPoint. Oh, my.